This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Kindly take paragraph 4 first. I'll place a few paragraphs from the writ petition. Who are the petitioners?
I'll be requesting you to make it because I have gone through your written notes on argument. Please take it in that way. You know my limitation.
I'll tell you, Lordship. I'll place a few paragraphs of the writ petition to demonstrate what was the scope of the writ petition. Then a few paragraphs from my opposition, and then I'll go to my written notes.
আজি কত তারিখ একটু পেন্সিলটা কেটে দিন ভালো পেন্সিল এটা একটু কেটে দিন
এটা ডং করে আওয়াজ হচ্ছে Now please have a look to paragraph 4 first.
Which are the paragraphs you are going to refer?
4, 5, then 6. This is very important. 6, 7, 8, 9. Then comes 12 and 13. Rest I don't want to place. Paragraph 4 says that the petitioners, they had participated in the process for the work education group only. But they were not successful. That they accept in paragraph 4. Then paragraph 5 is, petitioner states that on scrutinizing the merit list, several discrepancies cropped up.
Mr. Dotto, I have clarified in one of the orders also. There are two separate challenges. One is notice creating supernumerary post. Since recommendations have already been made, the urgency demands that issue should be addressed first. Then the inquiry, all the CBI inquiry, discrepancy. So please concentrate on the first challenge, to that whether the creation of supernumerary post is justified or not. That is the main challenge.
My purpose first would be whether at all they can throw a challenge. That is why, Millard, these paragraphs.
No, that is what exactly. Tell me 5.
But every bad thing, Millard, cannot come to the court. But bad things must come to the court at the appropriate time through the appropriate persons. What is happening in law college, B.Ed college students may not be interested about that.
I understand. Come to paragraph 5.
So first is paragraph 4, Millard, where they say that they could not succeed. Then paragraph 5, they found certain discrepancies. Now, when did these discrepancies arise? Definitely, Millard, at the very beginning or during the selection process. It cannot happen thereafter. Very well. But I just indicate my mind. Then, Millard, in paragraph 5, they say a lot more things. Very good. First point is discrepancies found out when and why there was no contemporaneous challenge. Then please take, Millard, I can understand that there was no contemporaneous challenge because possibly they were trying to get the papers through Right to Information Act. Please take paragraph 6, 7 and 8. 6 says, your petitioners state that consequently many of the instant writ petitioners filed an application under Right to Information Act before the concerned authorities asking for the details of their OMR sheet along with question booklet, series and answers. However, either, this sentence is very important. This actually takes the court for a ride. My lords would kindly take judicial notice of how casually people try to come before the court. However, either there were no replies or it was stated by the concerned authorities that relevant information are not available to the respondents since the office of the concerned respondents have been sealed pursuant to the orders of the High Court. This is a pleading. Either you say, I have applied, this is my application, 30 days, now 45 days, whatever is the period for replying, they have not replied. If they have not replied, the procedure is that you have to go up in appeal. Again, if there is no reply, you go up in second appeal. Now, in this casual manner, somebody saying that, okay, we have applied, there might have been no reply, this, that, etc. coming before the court. But the petitioners should have first satisfied the court that how did they carry their right to procure information, which is a fundamental right. Right to Information Act is not something which gives an extra right. It only lays down a procedure, mechanism. Do this first, give some fees, not replied, go higher up, etc. I do not know when they have applied, be that as it may. A complete lack of particulars.
Yes, understood. I've got you. So this is paragraph 6.
Yes, 6, 7, 8 is on right to information.
All these are right to information.
Yes. Then paragraph 9, they apprehend that the OMR sheets have been manipulated.
It's 12.
Then your Lordship may kindly take me, Lord. 12 is the impugned orders. 12 and 13. When are the impugned orders issued? Or 19th of May 2022 and 14th of October 2022.
No, this is 14th October is for
that notification for counseling.
this is notification.
Yes.
But original notice for creation is
19th
May.
May.
14th October is the date of counseling.
No, the notice for counseling.
Notice for counseling. Yes.
Lordship may kindly, my lord, note one date. That is the date of publication of the panel, which was on 12th of December 2018. All these OMR sheet, manipulation, corruption, X, Y, Z, whatever they have said, apart from paragraph 12 and 13, they have all happened prior to 12/12/2018.
Prior to
Yes.
22 is the creation.
No.
Oh, these are they happened.
The OMR sheet, manipulation, corruption, X, Y, Z, whatever they say, had happened prior to 12/12/2018.
What you were driving at?
But the writ petition is filed on 15th of November 2022.
12/12/2018.
12/12/2018 is the publication of the panel. There is no dispute on dates.
Yes.
Writ petition is affirmed on 15th of November 2022. Almost, my lord, 4 years
Yes.
after, my lord, the publication of the panel. Now, please have a look to the prayers now. First prayer is man number so and so to provide your petitioners with the original OMR sheets as submitted by the petitioner in respect of first SLST for the post of assistant teacher in upper primary physical education, work education. Prayer made after 4 years to get their OMR sheets. Now, these are all abandoning the process of Right to Information Act. If at all they had applied, I'm doubtful whether they have applied or not. Let us not go into those ancillary issues. First is after 4 years. Second is abandoning a process which, according to them, they had set in motion. Whether we had a writ court can be approached after initiating a process or setting in motion a process, then abandoning it, and one fine morning trying to make out a cause of action.
For the purpose of knowing whatever they are in mind, their mind, allegations on other things,
Yes.
they set at motion, they resorted to this Right to
RTI.
Information Act,
Yes.
but
When?
Uh,
Nobody knows.
assuming they have approached, but according to you, as soon as Reed Court is approached, you have abandoned it, even exhausting that procedure as has been contemplated in the Act itself.
Wait, something like, my lord,
Yes.
there is something like, to give an analogy to your lordship, my lord, filing a suit in respect of which writ petition is also maintainable. Say a suit filed against the state, my lord, after serving section 80 notice and all that. And after pursuing the suit for say 1 year, you abandon the suit and file a writ petition with the same relief. There, my lord, our courts have held that if you set in motion a particular process where more than one remedy avenues are available, you cannot abandon that and come switch over to the writ court for your remedy by abandoning. If required, I'll place that judgment.
So this is possibly not necessary, because this is another way of, that is why if it is on the self-same cause of action, you cannot pursue two remedies before two forum of law.
Right.
You have to elect.
Therefore, prayer A cannot be entertained by your lordship today. Prayer B, can you have a look to prayer B? To publish the original OMR sheets of all the candidates who have been enlisted in the merit list, so and so. Apart from the delay aspect, my lord, this would be, as your lordship has, my lord, observed, pursuing parallel remedies. In a case of parallel remedy, my lord, writ is the bar. Something different, but at least if you have asked me, I would say, how will you bar a writ? But the Supreme Court says so. In a case of parallel remedy, if you have taken recourse to one process, writ is barred. Then kindly take, my lord, C.
To your knowledge, I am not considering at this stage mainly these reliefs, because there are other aspects to look into.
No, if your lordship is of the view that prayer A, B, C would not be considered.
If it affects the maintainability, if it affects the bar, then of course it cannot be prima facie. But I want to hear you from that. You have concentrated on your written notes also, that this is really the larger issue to this, whether these CBI inquiry, all these things regarding the opening the entire thing. This will requires a larger aspect. Very well, you so far this.
But I'll come back to this. But after my lord addressing your lordship, my lord, on the main issue. My lord, to address on the main issue, that is 14th May and 10th December, my first submission would be in continuation with what I am so far saying.
Yes. I have taken note of it. Very well.
A person or a group of persons, whether they can get a cause of action merely because some supernumerary posts are created. That's why I tried to say that what is happening in law college, the B.Ed students are not entitled to.
And there must be a nexus between these two, otherwise not.
In the process, rightly or wrongly, you could not succeed. Let us presume some corruption in it. Let us presume, for argument's sake, blank OMR sheets, X, Y, Z. There are so many things which are said in court. Ultimately, investigation, nothing is found. Be that as it may. But, my lord, even assuming that, my lord, there was certain discrepancies or wrongful deprivation of the petitioner's right. First is, my lord, the petitioners did not come before this court contemporaneously to enforce their right of deprivation, against deprivation, discrimination, corruption, XYZ. That is why, my lord, this date is very important, 12/12/2018.
2018.
My lord, your lordships have, my lord, for your lordship's convenience, if I may use this expression, have held that though there is no period of limitation to file a writ petition, but ordinarily the period to file a suit should be considered as a reasonable period for entertaining a writ petition, unless you can satisfy the court that I could not come within 3 years, 1 year, whatever may be the ordinary period of limitation, for certain justified reason. Therefore, something which has happened more than almost 4 years before the filing of the writ petition, those something, my lord, cannot be a triggering factor to file a writ petition before this court, number one. And number two, creation of supernumerary post does not give any cause of action to whom? Unsuccessful candidates.
That you have addressed on the point of maintainability and decisions cited.
In Bengali, bail pakle kake ki?
কাকে দিতে সবকিছু।
Now, you are rightly or wrongly not in the fray. This is not a public interest litigation. Therefore, my lord, please consider this, my lord, whether point number one, apropos the supernumerary aspect, is whether people who were sitting in their homes, people who were fence sitters, would get a cause of action merely because some posts have been created. Wrongly created. Let us assume for argument's sake, wrongly created. Lord, keeping this, my lord, as my first point, now, my lord, kindly take note my affidavit in opposition, 3 pages, my lord, I'll just place. From pages 4 to 7.
Opposition by state.
Date. এই দেখুন রঞ্জন কুমার ঝা, দাঁড়ান দেখে ডেটটা বলে দিচ্ছি। হ্যাঁ, 28 নভেম্বর। 28 নভেম্বর। Please take note paragraph 4 first. I can skip over paragraph 4, my lord. Lordship need not take trouble, my lord. Please take note paragraph 5C at page 4. In view of ensuring that the students at large are not made to suffer, the decision to create supernumerary posts for work education and physical education was taken. The justification for the same is elaborately provided herein below. There were a number of cases alleging rank jumping in class 9 to 12 and Group C, Group D selection process. The Honorable Court for Ensuring Justice gave direction concerning appointment to one so-and-so, passed in so-and-so. The issues raised were long-standing and had resulted in huge agitation, demonstration, strikes from waitlisted candidates who were seeking job as teachers. In order to provide fair treatment to the waitlisted candidate who claimed to have been adversely affected, the state government, as an exigency, created such supernumerary posts. As such, supernumerary posts have been created in public interest and in the interest of education. The answering respondent gives so-and-so. Then kindly take note page number 5. The only intention of the state government was to provide adequate teachers for the schools in the interest and benefit of the students and also to protect the complaining candidates. Section 25 of the Right to Education Act emphasizes fundamental right for the children up to 14 years of age to get free, compulsory and quality education, and the state is under an obligation to maintain adequate pupil-teacher ratio. Hence, the state, in order to comply with its constitutional and statutory responsibility towards children at large, has taken the instant policy decision not only in favor of the education for the children, but also in order to extend the benefit of employment to a large number of unemployed youth of West Bengal who were complaining unfair treatment.
Work
Recapitulated that the selection process.
Work education, physical education are subjects up to class 8.
Subject is there.
No,
is not
they are subjects for up to class 8 or is 9, 10?
Here it is up to 8, but these are subjects are there.
No.
9, 10 where I have to take instruction. Possibly is there.
Work education, physical education.
But I've seen my sisters giving work education examination in 9, 10 also.
9, 10. I want to know 9, 10. So there are two sets of appointment in this 2016 selection for upper primary and for the
11, 12.
9, 10.
9, 10, 11, 12. Yes. We are concerned with upper primary.
Upper primary.
In this
But I want to know from you that whether
সেটা ঠিক আছে না জজ স্যার জিজ্ঞেস করছেন যে 9, 10, 11, 12 ওতে ওই সাবজেক্ট দুটো আছে কিনা
that is 9, 10 also work education. My knowledge goes
But
9,
I
10.
have to check up, but speaking from memory,
9, 10 is
I
also.
think it's there.
Then 9, 10 there is another selection test for work education, physical education. Along with that,
But these are the subject matter of several other litigations.
yes.
Then when I was placing subparagraph 4, it is recapitulated that the selection process for recruiting teachers had started in 2016 and took a long time to complete the same. In between, the schools and the students suffered for want of teachers. Considering the said extraordinary situation for such delay in recruiting teachers and acute want of teachers, while keeping in mind the benefit of students, the government created the said supernumerary post with the approval of the cabinet for accommodating all the work education and physical education wait-listed candidates. The supernumerary post creation order dated 19th May itself contains direction upon the director of school education to place the teachers against the schools which are in need of teachers following the so and so. As such, supernumerary posts so created for physical and work education teachers have been allotted for the benefit of students to the schools having less than the required teachers, schools adversely affected by transfer of teachers, and the schools having no work education or physical education teacher. The state government had the power of creation of supernumerary posts.
This is very specialized work education and physical education. Therefore, less than required teacher, this is no domain of consideration for creation of work education. The last one,
Yes.
the schools having no work education and physical education teacher.
No, it means that posts are there, subject is there, but there is not a single teacher. Yes.
Therefore, the school less than required teacher means this is not a consideration of the creation of work education, physical education. Schools adversely affected by transfer of the all are relatable to work education and physical education teachers, right?
But put it in a group. These people or the supernumerary posts or these people, the waitlisted candidates would be provided for schools where there is lack of teachers.
Of work education,
Yes, yes, definitely. Not Bengali or English.
Bengali or mathematics teacher lack that can be met.
Well, confined to these two subjects.
These two subjects in upper
Upper primary.
Upper primary. 9, 10 no work education serial. Sure.
No, I'm not saying. I'm saying that
Notification is confined to physical education, work education, upper primary. Up to 8.
yes.
Yes, 5 to 8.
Yes, then
Then we'll have subparagraph DI. That creation of supernumerary post is the prerogative of the executive and is within the executive power of governance invoked by the government from time to time. In the instant case, the supernumerary posts are created to extend benefits to the students concerned, to generate service opportunity for the waitlisted candidates, and also to fill up in the gap created due to delay in completion of the last recruitment process. It is also stated here that as the state is statutorily empowered to sanction posts against vacancies in the school, similarly, the welfare state in pursuit of exigency retains the power to create supernumerary posts as well. Rule 2P of the rules inter alia says that vacancy includes post newly created by the state government or any other reasons as the state government may by order determine. So in any event, the recruitment rules itself provides for authority for creation of posts. As per rules, the waitlisted candidates have a chance to be recommended and appointed if there is a vacancy for exhausting the panel. In extraordinary situation, in exercise of powers under section 19 of the Act, the state government for the benefit of the students had given direction for recommendation of the waitlisted candidates in the post of so and so, subject to outcome of the pending litigation. Then section 10 of the Control of Expenditure Act further empowers the state to sanction additional posts. The supernumerary posts so created had been created considering the budgetary allocation, sanction of finance department, and finally approval of the cabinet. As such, the posts so created are created within the authority of the state government. Well, I will not trouble your lordship with the rest of it. Really?
Yes, this is according to these vacancy includes post newly created by the state and read together with section 10 of the Control of Expenditure Act. So this post will not be in existence as this person goes, that ends. It is a new set of vacancy. This is the affidavit of yours. Then, sir.
Therefore, my lord, the first point, again with the caveat that these are not maintainable at the instance of the writ petitioner, the first point is whether the state has a power to create posts or not. The answer is always yes. The second question is, if the state has the power, whether the state can create additional posts or not. In my very respectful and humble submission, that also should be yes. Now the question is, which may fall for consideration, is that if you wanted to create extra posts, or the state wanted to create extra posts, why supernumerary posts?
No, there is no doubt in my mind that is the court, state has a power to create extra posts. No doubt about it. These are executive actions. Please address on this.
Yes.
However, the judicial review is open.
But now your lordship may kindly come to me, lord, my written notes of submission.
Exactly. Your obligation to enforce 21A.
But these are all there, my lord. I don't think that I need to trouble your lordship. Paragraph 2, my lord, I have spoken of Article 21A. Then paragraph 3, my lord, I have spoken of my obligation to provide teachers. Then at paragraph 4, my lord, I have spoken of, my lord, the status of the petitioners as unsuccessful candidates. Then, my lord, in paragraph 5, my lord, I have said that there is no right of employment under the Constitution.
I will be asking you one question. That if a statutory rule occupies the field and your executive power to create post, both are there. Please make a bridge between these two for my understanding.
The answer is very simple, my lord. Executive action fills up the gap.
Achha. Even
the legislative sphere. So if I have
if there is a gap.
Yes.
If there is a gap,
yes,
of course, it will fill up this. Executive action will fill up the gap. So you want either you say there is a gap or you say there is no gap. That I want to know from you.
First is, my lord, my answer was to the query of the court. But possibly, subject to correction, that principle would not apply.
Achha.
Why will it not apply? Because nobody is questioning, my lord, my power either to legislate?
No, no, no. No one.
Is questioning. That's why I'm saying
There is no doubt about
no
it.
doubt about that. Nobody is also questioning my power of executive action.
No, certainly not. But one question
Nobody
is there.
is also, Millard, questioning my power to create posts. The question subject to correction by the court is whether taking into consideration the gamut of the situation, whether supernumerary posts could have been created. That is the question. Again, supernumerary post creation again cannot be doubted. Power to create cannot be doubted. The question in my respectful, humble understanding is taking note of the facts and circumstances, whether here supernumerary posts should have been created or not.
Yes, then.
Milord, I have laid bare my cards. I have said that why have I created? I have created this for two reasons, primarily two reasons. One is to provide teachers. The other is, since there are waitlisted candidates, to accommodate them. Milord, there is no challenge thrown to the preparation of the wait lists, either contemporaneously or belatedly in this proceeding. There is no challenge that the waitlisted candidates have been picked and chosen to put them in the waiting list.
No, no, no.
No challenge.
There is large challenge was sought to be made that
Nothing.
there is some corruption, all these things. But the waitlisted candidates, creation of waitlist is the product of manipulation of things. Possibly it is not.
Nothing is there. Therefore, we need to, Millard, subject to correction, Millard, confine ourselves to only this question as to whether under the facts or situation over here, creation of the supernumerary post can be doubted. Power is not doubted. Only creation is doubted. Why have you created this? Why have you not gone for a fresh selection? Had you gone for a fresh selection, we could have offered our candidature. These are, Millard, more or less the points.
Yes. এটা দেখি judgment is volume 1 to though. Please come to paragraph 6. Okay.
Yes, but of my, your Lordship is referring to my notes.
Yes, that is what paragraph
Yes.
6.
Well, we can skip over para 6 also, because para 6 is a fact that state cabinet has approved. Please take para 7 onwards.
No, para 6 you have referred to SS Goel.
Para 6, I'm sorry.
You have referred to SS Goel.
Paragraph number milche na karo. No, I think Millard, my para 6 is the state cabinet has approved.
Huh? No, this was given to me on 24th September.
Your written notes on behalf of the state respondents, Millard?
Yes, state respondent. It starts with work education to Article 21A, following up legislation, providing teachers in subjects.
Can I have a look to it? Can you permit me?
No,
কি দিচ্ছিস? বেঞ্চের মতো একই তো না, এই অ্যাজ আ ফলো আপ লেজিসলেশন এটা কোথায়? জজ সাহেবকে তো অন্য কিছু দেওয়া হবে। এই প্রোভাইডিং টিচার এটা তো নেই, না এটা আছে, প্যারাগ্রাফ নাম্বার 3টা আমাদের নেই।
কপি আছে? এটা কপি দাও।
প্যারা 5 হয়ে গেছে। না রে, তো অনেক চেঞ্জ। Yes.
এখানে পাঠাও।
একই দিয়ে তো
No, you cannot change it in this way.
No,
I have read it all over.
no, we are not changing.
There are
I have to change myself. What
It is very precise. I have read it. I have gone through. It's very precise.
But we try to
Regarding
make it as
the
precise as
executive power, the main thrust was that the executive power, scope of judicial review. My query would be to Advocate General would be that whether when the field is occupied, any statutory rules, this executive power while exercising, whether legislature is have any responsibility to take adhering to that or not. That much, that far.
হুম হুম এই যে জোসেফের কাছে যেটা আছে সেটা দেখ কিন্তু আমার কাছেও তো নেই
এটা ফটোকপি করে ওকে দাও তো এটা থেকে
So we have copies. We must be having copies.
you have given me.
Yes, is definitely. I think that the older one is
I think this is very precise.
corrected one has gone
Yes,
to the
correct
right
one is
place.
here, and this is very precise.
Yes, yes. No, no, no. ওখানে দু তিনটে প্যারাগ্রাফ মাঝে অ্যাড আছে আমি দেখলাম
Yes, which is common. Place it. SS Goel, you are getting.
Yes, yes.
Place that
Well, I
paragraph.
have. But my SS Goel is paragraph 11 and 12.
Yes, read out the paragraph.
Because my paragraph 11 starts like this, which has SS Goel. Creating a supernumerary post is one such policy. There is another paragraph with SS Goel. The petitioners cannot have any grievance.
This is what this is the
This is the
exactly. It
paragraph-
has been placed in a place where it should have been.
Yes.
Because you are proceeding from the view as you have started today 2018-2022 unsuccessful challenge to this decision. There is no allegation on the waiting list, but ultimately you have come. This is covering. Please read out.
Milord, if your lordships want me to read
Petitioners cannot have any
yes,
grievance
yeah,
over
I'll
the
place
policy.
that. I'll place that paragraph. The petitioners cannot have any grievance over the policy to create supernumerary posts since they could not prove their merit to be impaneled in the merit list or in the wait list. The judgment rendered in SS Goel, paragraph 23, stating one fails to understand what grievance the petitioner could have against the scheme. They are not eligible for being considered for supernumerary post as per the scheme. They have thus no locus standi to challenge it. Therefore, my lord, my submission, opening submission is
It is matching with the synchronization you have made over here. Yes.
not challenged your exclusion contemporaneously. You have not challenged the creation of the wait list contemporaneously or even today. What you are saying is that why have you created this? How have you created this? How could you do this? Whether being an unsuccessful candidate, you can throw a challenge to this. But the answer is SS Goel.
Then you have precisely creation of supernumerary post a policy matter.
Right. That is again SS Goel. Well, this is with the previous para is paragraph number before my lord is paragraph number
6, then 7. It
6
has
is the one which I've read now.
yes.
I'll just note down the paragraphs. Kind.
You must have this one.
No, no, I গেল কি করে?
আমার মেলে নেই কোথাও
এই সুমিতা কি আমাদের দিয়েছিল? Yes, SS Goel was been discussed and says policy matter of government wherein the constitutional courts under 226 of the Constitution have refrained from interfering.
This is para 7 in your lordship's.
Para 7.
Yes.
Para 7 again 78 SCC online. This is Delhi judgment.
Right, right.
This was SS Goel again university, and this is with regard to creation of supernumerary post.
Right. But it specifically says that people ineligible to the supernumerary post have no locus to challenge.
দাঁড়াও এটা বোধহয় দেয়নি এদিকে দেখো তো দেখো তো But you did not provide me the 78 SCC online in these two bunch.
Violation.
78 SCC online, I could not find.
এসব করেছিস না?
It's a Delhi High Court judgment. 70, please take note. Now use your pen at least for once and
Nowadays,
not that pen.
I'll mark it here.
78 SCC online Delhi 82. That has not been provided to me. Please provide me this one. Then again, policy decision on recruitment. Creation of post is not amenable to judicial review. This is exactly and precisely this has been made. Unnecessary wastage of time will not do.
জাজমেন্টের কম্পাইলেশনটা আমাদের তো একটাই বলেন রে আমাদের কটা কোন হয়ে যায় নিয়ার কনফিউশন
These are please see which paragraph this is.
এই তো দিল্লি আছে।
আচ্ছা আচ্ছা
Ache?
হ্যাঁ দিল্লি আছে। Compilation is matching.
kindly take me to the first volume page number 73
তোমার কাছে তো দিতে হবে।
না এটা তো 73
First one page 70.
that is SS Goel
Acha. Sorry, I missed it then. Then the next one,
yes
policy decision on recruitment, creation of post is not amenable to judicial review. Are you getting it in your copy?
but again I've got lost, please give me a moment Miller. But how does the paragraph start, Miller?
Policy decision on recruitment,
15 yes
creation of a post is not amenable to judicial review
correct
unless the same is arbitrary.
right
Where the dominant object is to enforce fundamental rights and to comply with statutory obligations, a decision to create supernumerary post cannot be alleged to be arbitrary. The judgment rendered in state of Odisha versus Vikari Charan Khuntia as reported in 2003 10 SCC 144,
right
2008 9 SCC 242,
but in 2008-9 SCC 242
242 para 47.
Miller, that 47 kindly Miller correct it should be para 37
Official liquidator versus 2008-10 SCC page 1, paragraph 100, 105, 108, 112, 106, 116.
16 right
Lieutenant CDR M. Normesh versus Union of India, 2018-16 SCC 195, paras 25, 26.
yes
These are the on this point.
Miller, this is paragraph number Miller in your
25, 26.
Miller the paragraph number of the written notes
Oh, this is of 8, paragraph 8.
right and I'm so
You
sorry
must
Miller.
have the copy of it.
No, I have it, but I'll have to find it out today, Miller.
Then there is no right to employment under the constitution.
But this is
One has a right to be considered for appointment in a selection process.
but this is para 9 in your lordships.
Yes.
এই একটা ফটোকপি করে দেবেন তো আমায়
Yes, yes. এটাকে একটা ফটোকপি করে দিয়ে দিন তো কিশোরকে।
রচাবের কোয়ারি গুলো নিশ্চয়ই লেখা থাকবে ওখানে
Now, this was a very advantageous for me because you know the first line, there is no right to employment under the
Yes, yes.
constitution. Till date, right to education maybe, right to employment is not. Of course, one has a right to be considered for appointment. A selection process in a selection process. The petitioners have exhausted such right, but could not succeed having a placement either in the selection or wait list. Therefore, cannot assert any legal. It is coming in sequence, Mr. Dutt. It is coming in possibly ultimately in after drafting it, you have
but I think that I have Miller changed the sequence possibly
and this is the final sequence it has come because the parity, the sequentially it is coming down one after another. Creation of supernumerary post is indeed to promote the objective of Article 21A. Have you got it?
দেখ তো এটা কোথায়
Such power has a conferred undoubtedly in public interest, not for individual or private gain.
this paragraph Miller I can't find
Are you getting the word supernumerary?
The word supernumerary is
was discussed by the Honorable Supreme Court, and Supreme Court supernumerary posts have been held to be a post exceeding the usual stated or prescribed number. The judgment
this
is
is
Chandan Banerjee,
this is paragraph number
12. So what I will be requesting you,
yes, ma'am.
so for the policy decision, it is mainly thrusting on now the policy decision. Would you like to place, first of all, Goel, this was for the regarding their the locus and other points also, it is covering that. But the paragraph 8 in my note, policy decision on recruitment, creation of a post is not amenable to judicial review. Have you got it in your?
Is that is our 15, my lords.
8. 8. Please place. Yeah, this 3:30
Huh.
3:30.
That I've got confused by now. But please take it with some other team.
No, tomorrow.
Hey, tomorrow. Well, I've got a better.
Mr. Dotto, please, you understand my difficulty.
My difficulty.
No, you, Mr. Dotto, please cooperate this time. Please cooperate this time.
Kindly
Please cooperate.
allow me to utter one complete sentence. Well, I am on legs before the division bench, which is not the regular bench, which is going to reassemble tomorrow. And Milord, I am continuing over.
Mr. Dotto, please appreciate my position.
Keep it after.
You understand?
Keep
At
it
least whatever I hear, I have to
Keep it
write.
One
I have to, because of this intervention of two successive, this circuit bench, I have lost a lot of time.
well, keep it one day after. I'm not asking for the.
No, I will not. First of all, it must be time bound. It must be time bound. Please don't repeat the points.
No. Certainly not.
I will not allow everyone, because I have to control, my I have to complete it, because, otherwise I have to release it.
But please keep it on Thursday, Milord.
No, Thursday.
Arey Baba, kya tu-
No, tomorrow, how long the division bench will continue?
Well, it will continue. I cannot finish tomorrow before the division bench.
But after whatever way you have been released, it didn't come. I am giving the copy. এটাকে এখনই কপি করুন তো, এগুলোকে দাগগুলোকে তুলুন আগে,
দাগগুলো মুছে দেবে।
এই যে এগুলোকে সবগুলো কষ্ট করে পড়ে আসলাম গিয়ে।
No. Milord, may I say one thing, Milord? I'll try to find out if it is not available with my juniors, then only Milord, I'll disturb your lordship's officer. Because I really don't want to take your lordship's copy. If it is not available, Milord, what I'll do is no.
সুমিতা তো বললো,
Milord, I'll try to
I
find.
must have with your junior Sumita, she has given it. I rather she together with it.
I'll have to check with her whether it is with her or not. I'll check with her. Milord, once it is available,
No, not once. Just tell me tomorrow you have the division bench from 10:30.
no, 11. 2 o'clock.
2 o'clock. Morning 1 hour. Give morning,
Very difficult.
Mr. Dotto. My difficulty you understand.
Milord, after reopening on all Saturdays and Sundays, continuous 15 to 16 hours chamber I have to attend. 15 to 16.
That is the demand of your
No,
situation.
I cannot help it, Milord.
You cannot help it. I
She
know.
knows, Milord,
I
how long have I spoken today? 1 hour maximum? This required at least 10 hours of preparation.
no.
No.
I have practiced for some time, not in your in your volume.
Achha, theek hai.
But you know that because I don't have that much of
No, I think
Stomach.
it's right. Volume differs more.
differs in the other side.
Deferred.
Deferred, yes.
but we are not confined on that simple small book. You have to venture here, there, where. Now, if you understand my difficulty, because I have to hear.
বুধবার করে দিই ওখানে দরকার হলে
শেষে রাখো তাহলে, 3টের সময় রাখো।
ওখানে বলে দেবো যে তুমি ওখানে বলবো যে তুমি সেকেন্ড হাফে শোনো না ফার্স্ট হাফে দিচ্ছি এখানে আর পাশে না বললি তো